So what if you say to a debt collector, I dispute this debt, and then they update your credit report without marking it as disputed? Can you sue them? And what about this idea of a bona fide error, some type of defense that the debt collector has? That's what we'll cover in this case. Now, this is a lengthy opinion, and there's actually two opinions here. One is from what's called the magistrate judge, who prepares what's called a report and recommendation. And then the district court judge is the one that makes the final decision, and the judge accepted everything the magistrate court said. So there's a lot of pages, kind of big print, but still, this is going to take us a while to go through. But I think it's very, very important to understand about emotional distress damages and this idea of a bona fide error. So we're talking about the FDCPA, Fair Debt Collection Practices Act. And this is something that at my law firm, I'm recording this in May, and we'll probably have filed about 21 FDCPA cases this month. So this is something that we have a lot of experience with, and dealing with emotional distress coming from violations of the FDCPA, dealing with collectors who always want to say, well, we didn't break the law. But if we did break the law, it's bona fide error, so we don't have to pay you anything. So if you're interested in this, I think it'll be worth your time to stick around. So the magistrate judge says, I recommend the defendant, that's the debt collector's motion for summary judgment be denied, and the plaintiff, the consumer's motion for summary judgment be granted. So let's see what happens here. We've got a debt collector named Cedars here, and let me fix this scrolling here. And this Cedars debt collector, they're trying to collect a debt. And so then when they first report it, it's not marked as disputed. And I will say this, the consumer, the plaintiff's pretty lucky because they use Credit Karma. And it's easy for a judge to say, hey, that's not your real data. That's not directly from TransUnion, Experian, Equifax, etc. But in any event, it was not marked as disputed. Then the plaintiff, November 18th, sent a letter disputing it. It was received on 22nd, and they did not mark it as disputed, even though they updated it. So you see, letter December 18th, received November 22nd, updated on December 1st, not marked as disputed. And then the consumer says, well, I suffered anxiety, emotional distress, reflex issues, things like that. The defendant says, we got the letter, but we unfortunately didn't process it correctly. And so the defendant says, well, look, this affidavit about, I had to be treated by my doctor and had all this stress, this contradicts the testimony. This is self-serving. And so none of this should be considered. And the court said, and let me just back up. So if you give a deposition and then you file an affidavit after that, an affidavit is just a sworn statement that directly contradicts your deposition, and there's no explanation for why there's this contradiction, then the judge has the option to disregard your affidavit. It says this court is obligated to accept statements, self-serving or not. Defendants love to say, well, this is a self-serving statement. Let me tell you what, we're going to see a self-serving statement. It's from the defendant debt collector. It's the most self-serving statement you can imagine. It's worthless, okay? But it's not worthless because it's self-serving. It's worthless because it has no detail, and it avoids actually saying anything substantive. But the court says, look, whether or not the plaintiff's affidavit is self-serving doesn't matter. So here's Loesch versus NationStar. We have a whole video on this. We talked about this in the last case video. This is an 11th Circuit appellate court decision. 11th Circuit's over Alabama, Georgia, Florida as far as federal court. And this was a discharged debt that was kept on there. They disputed it. It wasn't fixed. And they said, hey, I have emotional distress. And the court said the self-serving affidavit is sufficient evidence for standing and for emotional distress damages. Here's another one, City of Miami Beach. Self-serving, but that alone does not permit us to disregard them. And then they say some of the things the defendant argues about, like, well, hey, we ultimately removed the debt. So what? It doesn't mean anything. And the price of security deposit, you didn't have to pay more than you should have. It doesn't matter. Okay, so we're not going to go into this a lot of detail, but the court just makes the point that there are some things that may be additions, but they're not contradictions. The affidavit adds to, but does not contradict the deposition. And so, let's see, filed the lawsuit, then the defendant reported it disputed, and then had it deleted. All right, so here's summary judgment. So a lot of times we're dealing with a motion to dismiss standard, a Rule 12b-6. And sometimes this is called a failure to state a claim. And there we're looking at the complaint and saying, are the allegations, do they plead enough facts that it's plausible the plaintiff can win? At summary judgment, we're not doing that. We're saying, all right, now we have to actually develop the facts, get proof here. And then we say, are there issues of fact, really important facts, what we call material facts, that are in conflict, or is there none of that? And then who's entitled to judgment? And so both sides move for summary judgment here. All right, so let's drop down to standing. We're not going to look at this very much because we covered this in other ones, but you have an injury in fact. It's traceable. In other words, it was caused by the defendant's conduct. And then you can get relief in court. And it's a number of recent cases, 11 circuits recognize emotional injuries can constitute injuries in fact. So anxious, exploited, embarrassed, worthless. That's in truth in lending. Concrete injury for emotional stress, time spent contesting. All right, that's that Loesch case. Here's a Midland case, FDCPA. Stressed and worried, couldn't sleep. And then points out other courts disagree with this. And let me finish the thing. It says, but look, I'm going to follow what the 11th Circuit's saying here. All right, so we can scroll down to here. Here's the FDCPA claim. So here's the point of it. Eliminate abusive debt collection, and then make sure those debt collectors that follow the law are not at a competitive disadvantage. And then to make sure that consumers are protected. And so what does it do? It prohibits unfair, unconscionable collection methods, conduct which harasses, oppresses, or abuses, any kind of false, misleading, deceptive statement, and you have to give certain disclosures. So here's what you have to do to win. Number one, you got to say, I've been the object of collection activity from a consumer debt. Consumer just means that it's not business, it's personal or household. Number two, the defendant is a debt collector. Number three, they engaged in an act which violated the law. So remember, in this context, the allegation is, I told you the account was disputed, and you updated the credit report, and you did not mark it as disputed. That is section 1692E8. It says, so here only the third element is in dispute. So they're not disputing this was a consumer debt, this was a consumer, and that this is a debt collector. So here we go. E8, communicating or threatening to communicate to any person, just think credit bureau, credit information which is known or should be known to be false. And then here's an example, including the failure to communicate that a disputed debt is disputed. So a plaintiff says, hey, you violated this when you reported the debt without marking it as disputed. Defendant says, whoa, not so fast. We win because here's the staff commentary from 1988 that says if we report a debt before we know it's disputed, we don't then have to mark it as disputed. Now, it's a complete mischaracterization of what the commentary says, okay? So, and they sort of argue this all the way through, and the judge is going to call them on the carpet for this. And so a number of courts have held debt collectors receive a dispute about a previously reported debt do not have an affirmative obligation to report the dispute after receiving it. So the defendant extrapolates that because it was reporting it undisputed before the dispute, it can continue to do so. I mean, just stop and think for a second. So if one day before they get the dispute, the collector reports it, then they can report it what? For all eternity and not mark it as disputed? It's ridiculous. Or the other approach is once you find out it's disputed, if you then update the report, Now you have to mark it as disputed. And that's actually what the law is. This is not a fair reading of the FTC commentary or the cases. You don't have to proactively communicate to anyone that a previously reported debt subsequently became disputed. That does not mean it's free to omit the fact if it chooses to make new reports. So it can stay silent, but if it wants to communicate about the debt after the dispute, it must report it as being disputed. So here's a case from the 10th Circuit. Debt collectors not have affirmative duty to notify the credit bureaus that a consumer disputes a debt unless they know of the dispute and elects to report to CRA. Here's this one. Elects to communicate credit information, must not omit a piece. And a number of courts in this circuit, the 11th Circuit, have found debt collector violates if it reports a debt to a credit agency, learns of the dispute, and then reports it again. So most collectors report once a month. So when you tell them that the debt is disputed, usually by the next month they're going to report it and update it, and then they have to mark it as disputed or they violate the law. So rejecting argument, defendant had no obligation to report debt is disputed after receiving dispute letter where they had affirmatively re-reported the debt. Here, defendant did not stay silent, rather reported the debt. And then the defendant relies on all these cases where there's no allegation there was reporting after finding out about the dispute. Okay. Now, there is one case, I think it's just wrong. It said, well, this is what's called batch reporting. And batch reporting did not communicate credit information. I don't think that's correct. But there's no argument here that this is batch reporting, whatever that is. Okay. So it's kind of an outlier case. And let's see here. So, okay, summary judgment be denied. Now they say we're going to have to look at this bona fide error defense. So what in the world is this? So it comes from section 1692K. It says, may not be liable in any action if the debt collector shows that the violation was not intentional, resulted from a bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid such error. So there's really three parts to that. One, it's got to be unintentional. You can't intentionally violate the law. You can't be reckless. Then number two, has to be a bona fide error. And we're going to find out that does not mean misunderstanding the FDCPA. And then finally, you have to have procedures that are very specific to address this particular violation and avoid it. You can't just say, we have procedures to not violate the law. That's not good enough. It's got to be very specific. So debt collector must show the violation, number one, was not intentional. Number two, bona fide error. Number three, occurred despite the maintenance procedures reasonably adapted. Failure to meet any one of these three is fatal to the defense and does not encompass mistakes of law or misinterpretations of the requirements of the act. And it instead protects against things like clerical or factual mistakes. So the defendant says, well, we satisfy the elements because it wasn't intentional. We had no knowledge of the dispute, no duty to update. Well, we know that's wrong. Number two, it's good faith mistake. And then number three, we have procedures to avoid this. And the procedures come from Chief Compliance Officer who says that basically if we find out we're doing something wrong, we fix it. All right. So court says, well, we've already determined that you do have an obligation under the law to report as disputed if you update the report. Thus, only argument with respect to the first element appears to be based on an erroneous reading of the FDCPA, and so they lose. Now, the argument could be, well, really the defense was that we routed the letter to the wrong department. Okay, magistrate judge does not address that. So, what happens is you have this report and recommendation, and then each side has a certain period of time to object to it and go up to the district court judge, the judge that typically has the jury trials, and say, hey, I think the magistrate judge got this wrong. Will you fix it? So we actually have that order here. And so the defendant did object, and the court's going to reject that. Okay. And so we're just going to skip down to where it gets kind of interesting. So they say, first of all, there's a question of fact. And if there's a question of fact, you can't have summary judgment as to causation of damages. Well, let's look at that first. Defendant argued plaintiff did not have standing to bring her claim because she had no injury. So we covered that a little bit in the previous opinion. And then they're raising this new argument about causation. And basically the district judge says, you know what, I'm not going to let you do that because here's what the 11th Circuit had said. It's fundamentally unfair to permit a litigant, a party, to set its case in motion before the magistrate, wait to see which way the wind was blowing, and received an unfavorable recommendation, shift gears before the district court judge. And then besides that, it says, look, at trial, there's going to be a trial on damages, and the plaintiff has to prove causation so you can have your defense in. All right, so let's go back up. They also say question fact regarding the bona fide error defense. So let's take a look at that. So remember, here are the three requirements. Non-intentional bona fide error occurred despite maintenance of procedures. Regarding the second element, bona fide error, it's made a good faith, genuine mistake as opposed to a contrived mistake. Like, oh, we're going to accidentally violate the law. Oh, it was just a mistake. And so the magistrate said this was a mistake of law, and that's not good enough. And that bona fide error only applies to things like clerical errors, mistakes of fact. I mean, it might be where in a letter where you mean to put a decimal point and instead a period gets put there. And so, instead of it saying $100, it looks like it's saying, $10,000 or something like that. So, let's see, defendant primarily argued had no obligation under the law, and that was wrong. Okay. And then they say, but even if we did err, we had reasonable procedures. And here's their self-serving affidavit. So we have procedures designed to avoid violations of the law. Okay, well, that's worthless. Like, you got to give us details about it. Like, not just say, well, we train our people not to violate law. No, you got to say, this exact type of violation that we did, here's the procedures. Procedure number 17 is designed to prevent this exact type of error. And here's what we do. And we actually maintain and we follow and we enforce this. They don't do any of that. Then they say we conduct an investigation and we train all of our people to follow the law. It's worthless. As a district court judge, given that the defendant completely failed to point to evidence of a mistake of the type to which bona fide error defense applies, the magistrate was correct in granting summary judgment. Now the defendant argues differently. They say, well, it's unintentional because we mishandled the mail. Yet the defendant points to no evidence to establish the letter was mishandled. All it is this self-serving affidavit, right, as they like to talk about it, was logged in accordance with our policies and procedures. Unfortunately, the letter was not sent through proper channels. Other than the description of an unfortunate occurrence, the chief compliance officer offers nothing to establish the failure to send the letter was due to a mistake. Like, we say it was unfortunate. What does that mean? You intentionally did it, and you're like, man, unfortunately, we got caught. There's no evidence of it. So it must be objectively reasonable. The conclusory statement about an unfortunate incident does nothing to create a question of fact. Okay? And so it goes on, should have found a question of fact, correct, and not evaluating procedures component because the defendant failed to establish the second element, that a genuine mistake as opposed to a contrived mistake occurred. And so the order stands and the parties are to have a jury trial, looks like July 10th, and they should be probably mediating it. I think, they're going to mediate it. And so I don't know what's happened, if it's settled or not settled. But anyway, I know that's kind of a long one, but I wanted you to see on the emotional distress, how the court handled that, and then most importantly about the bona fide error defense. And this also gives you some insight into how debt collectors treat this. I mean, this is a case that is not just at the complaint and the motion to dismiss stage. This is at summary judgment. I mean, they're going to trial in July, and if it hasn't settled. And this is the sort of the attitude and the mindset of these debt collectors. Like, oh yeah, we can do whatever we want. And then they get caught in that. They go, oh, well, it's bona fide error. Well, I'll just share this with you. When these debt collectors start arguing bona fide error, that's amateur hour, okay? Because unless it truly is like, we put, $10,000 instead of $10 by mistake, They just don't have procedures. You know, like they'll call third party. So third party is anybody other than you, your spouse, or your lawyer. And they say, oh, that was bona fide error. You go, well, show us your procedures about how to call people. Well, we just tell people not to violate the law. That's close enough, right? No, it's not close enough. And so what you're seeing here is very, very typical of these debt collectors. So anyway, hope that you enjoyed that, and I will catch you guys in the next video. Thanks a lot. Bye-bye.